I am only going to be discussing oil and gas development plans, or OGDPs. I'm not discussing comprehensive area plans or CAPs, and I'm also not going to be discussing other decisions the commission makes on permitting after hearing. This is OGDPs only, looking at 2023 and the first couple months of this year, 58 OGDPs in total. I'm going to first talk about the 2 OGDPs that were denied during the relevant look-back period, and I'm going to walk you through the 5 voting commissioners and tell you who voted what, who was a yes, who was a no, where is the vote a little bit unclear, and I'll explain that. Then I want to spend a little bit of time talking about the protested OGDPs over the past year or so, and I'm talking about those because before the so-called mission change rules, a third party's participation in the permitting of new oil and gas development was limited largely to public comment exclusively. And public comment hasn't gone anywhere. Any third party always has the opportunity to provide on an OGDP. Now, however, a third party can participate more in depth in a hearing, which typically includes filing a pre-hearing statement, a response statement, certainly getting more time at hearing to present than they otherwise would have had during a presumptive 3-minute public comment period, and perhaps most importantly, sponsoring witnesses and cross-examining witnesses of the applicant. To make an entry into this process, though, they have to show that they are an affected person, and so the commission is building its precedent for who's going to be considered an affected person through these dockets. I'm going to quickly go through decision timeframes and average length of director's recommendation, and then I'm going to spend most of my time talking about motions for reconsideration. So even though the ECMC has been evaluating 20 was the first year that they were subject to motions for reconsideration. And so it's kind of what it sounds like, where the applicant is saying, hey, you made a decision, are you sure? So I'm going to talk about the standard that the ECMC has reviewed those. I don't. Okay. The ECMC commissioners have to have a certain composition under statute. So Commissioner Ackerman is the representative with substantial wildlife experience. He served many roles with Colorado Parks and Wildlife. And he was a no vote on both of the OGDPs that were denied, as well as voting to deny the 2 motions to reconsider. Commissioner Mike Cross is the commission's representative with substantial experience in the oil and gas industry, who served in private natural resources law practice for many years. He was a yes on the first OGDP that was denied, although he voted along with his other 4 commissioners to deny the motion for reconsideration. For the second OGDP, For the second OGDP, the vote's a little confusing because it was a motion to deny, and he voted to, so he voted to deny the motion to deny. So some of you can track that double negative there. He wasn't saying yes, he was saying no to the no. And he specifically said that he would have preferred the OGDP be stayed rather than voted upon. So just keep that in mind. But then when it came up for motion for reconsideration, he agreed with his other 4 commissioners to deny the OGDP. Next up is Commissioner Karen McGowan. She is the commission's representative with substantial experience in public health, having served various roles with CDPHE. Commissioner McGowan was a no vote on one of the denials, and on the second vote, she voted along the lines of Commissioner Cross, so a no to a no, but also would have stayed. Like the other 2 commissioners, the 5 in total, she was a no on the motions to reconsider. Next, we have Commissioner John Messner. His experience is in local land use and planning. He was a Garfield County commissioner prior to his appointment. And, oh, I'm sorry, Gunnison County, thank you. And he was a no vote on the 2 OGDPs denied during the look-back period, and also voted to deny both motions for reconsideration. Finally, we have Chair Robbins. He is the representative with relevant expertise to aid in decision-making. He was in private law practice in Dacono, mostly helping local governments with oil and gas issues, and formerly served as the ECMC director as well. He would have voted to approve the first denial, a no vote on the second denial, but like the other 4 commissioners, was a no vote, or excuse me, a no vote to deny the motion to reconsider. So if you've been clocking how these votes went down, you can see that the denials were pretty close splits. It was 3-2 for each vote, but really the second vote is even closer because the 2 commissioners that would have denied actually just said stay. They didn't say necessarily deny. What is more interesting to me is that the commissioners were in lockstep 5-0 in the motions to deny. And I'm not going to speak about whether I think that the commission correctly approved or denied the OGDPs, or even whether they correctly denied or approved the motion to reconsider. I do have opinions on that, but you can find me at the steak fry for those. But what's more interesting to me, again, is this 5-0, and then the legal standard that they used for motions to reconsider, which we're going to return to. For the protested OGDPs, there were 3 OGDPs that were protested, at least initially, in this look-back period. So to be a protestant, you have to have what's called affected party status. And affected party status is a concept that you'll find in litigation called standing. And basically, this is a principle of judicial restraint where courts and agencies recognize that not everyone necessarily can participate, and just because you have an opinion doesn't necessarily mean you're directly impacted. You may say in a lay sense, you don't have a dog in this fight. So you have to show that you are an affected person. And there's 2 ways of getting affected person status. So the first way is automatic. If you're a federal agency, a state agency, tribal government, relevant local government, a special district with legal authority over the application, or a surface owner, this includes residents and tenants, within 2,000 feet of a proposed working pad surface, you're in. You don't need to make any additional showing. If you're not one of those classes of persons, though, you need to demonstrate that you are a so-called affected person. So your petition must identify an interest in the activity that is adversely affected by the proposed activity, allege that such an injury could be an injury in fact if the application is granted, and demonstrate that the injury alleged is not common to members of the general public. And this last point is kind of key because the statement of basis, specific statutory authority, and purpose to the mission change rules talks a little bit about what it means to make this individualized showing. And the example it gives is someone could be concerned about climate change or ozone formation, but that's common to all members of the public. And that won't necessarily be enough to make this affected person showing. Once a petitioner has made that threshold showing of those allegations, then the commission looks at several different things. It's going to look at whether the interest claimed is one protected or adversely affected by the application, whether a reasonable relationship exists between the interest claimed and the activity regulated, the likely impacts and magnitude of on the regulated activity, the likely impacts of the regulated activity on natural resources or wildlife, and finally, for a local government, its legal authority over the issues in the application. So this isn't an exhaustive list. The commission can consider other things as well, and it would be looking toward case law developed in litigation for instruction on standing. So in this docket, this was the only docket in the look-back period where the commission actually had to decide affected party status. So here, the petitioner, Citizens for a Healthy Community, CHC, did not qualify for automatic standing, and the applicant protested their ability to be an affected person. So they leaned heavily on two member organizations, a ditch company and an organic farmer's outfit, to allege that they had potential injuries because of their concerns of induced seismicity from produced water and water contamination. The applicant had argued that these supposed injuries were too speculative and too remote to be considered. Chair Robbins decided that these injuries were sufficient and no commissioner objected, so CHC was allowed to participate at hearing. Ultimately, though, even though petitioned and somewhat more involved than many other OGDP hearings, the commission decided that CHC's requests went outside of the rules and unanimously approved the OGDP. In the second docket, we have a really interesting question of how the commission would have ruled, because the protestant was a proximate local government. So while relevant local governments have automatic affected person status, proximate local governments do not, and here the applicant disputed whether the proximate local government had affected party status. The issue ended up being moot because the local government withdrew their protest on the condition of the hearing officer granting, which he did, the opportunity for a longer public comment, which here was 10 minutes. So they still participated meaningfully at hearing, and this was another unanimous OGDP approval. In the final protested docket, we had a relevant local government who also withdrew their presentation but provided public comment. Here, their controversy was minimized because the local government and the applicant had entered into an MOU, but the takeaway point I wanted to make about this affected person status structure is that first, the commission has been fairly lenient, at least in the one instance of who will get affected party status, and this tracks Colorado case law where standing has traditionally been fairly easy to satisfy. The second point I want to make is that even though petitions were withdrawn, the parties were still meaningfully participating at hearing and in a much deeper capacity than they would have if they were just doing public comment. Decision timeframes, and I did run the clock on this starting from an OGDP application submittal. Many of you know that applications are often amended, so this is from the very first submittal date. But we have 121 days was the shortest application, 260 days was the average, and the longest was 592 days. So for the average decision, you could gestate a human being in general before it gets out. For length of director's recommendation, so I wanted to look at this because when I was doing my research, I was curious if I'd find a correlation between the number of locations and the length of the director's recommendation. And I didn't necessarily find that, but on the other hand, one thing that operators and regulators will tell you alike is that everything is so site-specific. And so it also sort of makes sense that you wouldn't necessarily have a longer recommendation, although one of the longest ones did have 2 locations. I should also note that these recommendations are single-spaced documents, and this is exclusive of the attachments, which can sometimes be very robust. These would be things like CDPHE consultation letters and lots of other documentation. Okay, standard of review for motions for reconsideration. So in 2023, the commission faced its first ever motion for reconsideration. And so there is no actual ECMC rule that speaks to motions for reconsideration. There's no 500 series rule on point. Nothing explicitly prohibits motions for reconsideration. Nothing specifically says go ahead. Instead, there's Rule 517A, which is a catch-all, describing that the rules of Colorado Civil Procedure, or CRCP, generally apply unless inconsistent with the Act or the Commission's rules, or if an administrative law judge or hearing officer decides differently. So they look to the rules for guidance. They applied, I'm just going to use shorthand, CRCP section 115. And this provides that a motion to reconsider should only be granted if there is a manifest error of fact or law that clearly mandates a different result or other circumstance resulting in manifest injustice. I have that key language there in red. The law doesn't use a lot of adjectives. When it uses adjectives, it means business. So this heightener, this modifier of manifest is significant. The manifest error is a high standard, and it's called a high standard in the orders on the motions to reconsider. So even though this first OGDP that was denied 3-2, the motion to reconsider was denied 5-0. And the two commissioners that would have approved the OGDP, it wasn't as though they had changed their minds. And this is in the order. They said that they continued to believe the OGDP was approvable, but they didn't think there was manifest error. They didn't think that there was a manifest injustice, so the overall result wasn't disturbed. So is that error, is that standard the correct standard of review? I want to say that this was never, to my knowledge, discussed in the hearing. It was never disputed among the parties. They didn't spend a lot of time talking about what standard of review they would use. They just applied one. But it's something I've been thinking about a lot, because when you look at the whole rule, it begins by saying motions to reconsider interlocutory orders of the court. So the standard of review they use applies to interlocutory orders. And the rule even goes on to kind of explain further what it means. It says, we're not talking about motions to reconsider that are under CRCP 59 or 60. So in my view, the rule only applies to interlocutory orders. So what's an interlocutory order? An interlocutory order is an order that doesn't resolve the final merits. It's an interim step somewhere along the lines in a case. Think appointing a receiver, approval or denial of a preliminary junction, but it's not a final judgment. And a decision on an OGDP, by contrast, is a final judgment. And there's Colorado case law that explains that final judgments are reviewed under CRCP 59 or 60, and specifically relevant here, if you have a motion for reconsideration of a final order, you treat it as a motion to amend under CRCP 59. So what do we do under CRCP 59? Courts hold that you need to look at Rule CRCP 59D4, and there the commission can reconsider its decision or have a new hearing based on an error of law. You don't have a manifest error of law. You don't need to show manifest injustice. Simply put, the bar is lower. It's easier to prevail under Rule 59 than it is under Section 115. Does this make a difference? Well, we don't know, because the commission didn't talk about it. It may have, it may not have. This wasn't challenged. Neither of these denials were challenged in district court, so we also don't have a district court saying the commission applied the right or wrong decision, which also doesn't mean that the commission would have ultimately changed its mind. It's just a question of whether the standard was correct. But I wanted to point out this standard because it's very, very difficult to convince 5 people that there was a manifest error of law. And so, because it's so difficult, you may be wondering if parties have to file a motion for reconsideration before filing a lawsuit, and they don't. And it's actually stock language in ECMC orders to make that clear, that an application is not considered. And now that we have 2 examples of the commission applying this heightened standard, it'll be interesting to see if parties still wish to pursue a motion for reconsideration path. They might want to get more information into the administrative record, which is valid, or they might want to proceed. In general, though, we haven't seen litigation on denials, or for caps on that matter. If you do get to court and you're not looking at a motion to reconsider, The standard is, we often call it in shorthand, arbitrary and capricious. There are several grounds on that area, and they're listed here. But I think the important thing here is even once you get to district court, the standard of review is highly deferential. Courts can't substitute their judgment for that of the agencies, and even if a court would have made a different decision, it can't disturb that decision as long as there's substantial evidence in the record as a whole. Couple conclusions. First, I can't speak into microphones. Second, the OGDP review process takes a long time. Not many OGDPs have been protested, but those that have been protested have included meaningful participation even when protests were withdrawn. And we're seeing that the affected party person bar is closely hewing to Colorado case law on standing. And it's difficult to prevail on a motion to reconsider. So if there's any time left, I'm happy to open up to questions.
Raise your hand if you have a question. We have time just for a couple of questions. And I apologize, we just got a little bit behind me with our time stuff. So raise your hand. We'll get a microphone to you right away. 2 questions probably, and that'll be it. And then you can visit with her at lunch and the steak fry. So right over here, we've got a microphone coming right over to you. Who else wants a question? The second question, raise your hand. And I appreciate y'all's patience with our stuff.
I think it's working now. On the first docket you brought up there with Citizens for a Healthy Community, by giving them the affected party standing, does that set a precedence now that ECMC has to follow?
Well, it's still going to be case by case, but you would argue from analogy. So if a person was arguing that they had affected person status, they could say, we are like CHC because CHC alleged X, we're also alleging X. And by contrast, someone disputing that could try to distinguish them and say, well, CHC was ruled to have affected person status, but CHC was different because these protestants, aren't like CHC. So it's not binding in any way, but a person, entity similarly situated to CHC in a similar type of application would be more likely than not to have affected person status.
Thank you very much. And for Julia?